Hello, I'm Professor Annalisa Savaresi from the University of Eastern Finland. It's a pleasure to be here with you today, albeit only on video, to present the findings of a global toolbox on corporate climate litigation that relates specifically on human rights as a cause for action. Now, as many of you probably know already, there is extensive practice concerning the use of human rights law in climate litigation, and this practice is increasingly manifest also vis-à-vis corporate actors. Now, there are specific limitations concerning the use of human rights law against corporate actors. And these may be summarized as follows. First, there is limited legislation in this subject area. What do I mean by that? By and large, human rights law at the international or at the national level targets states. So the obligations in human rights law are obligations of states. And therefore, this legislation does not clearly outline specific human rights obligations for corporate actors. The second challenge is that there is limited practice. In other words, there have been relatively few judicial precedents where courts have relied on human rights law in litigation that concerns corporate actors. This report reviews the practice that does exist and does consider what strategies may be used going forward. In this connection, the report starts by looking at the obvious suspect, which is, again, milieu defensi, a case that I'm sure you have already discussed in other contexts because it's a milestone also for the use of human rights law. What the court did in milieu defensi, the famous case that was brought by NGO Milieu Defensie against Royal Dutch Shell in the Netherlands, was to rely, amongst others, on human rights law in order to delineate the contours of corporate obligations under tort law in the Netherlands. And this is a very significant precedent that is emblematic of extant litigation strategies that include references to international hard and soft human rights law instruments to corroborate arguments that are principally made on the basis of other sources of law, like tort law. Going forward, there is a building body of human rights due diligence law, however, that is going to increasingly, hopefully, fill in the gap in legislation that we have mentioned. So this new legislation is creating processes for which companies themselves manage their potential and actual adverse human rights impacts. And in this regard, one of the most significant developments is the recently adopted Directive on Corporate Sustainability Due Diligence of the European Union, but similar legislation is under consideration elsewhere. Now, the report outlines which are the essential components that must be considered in order to apply this legislation to climate action and impacts. So, to conclude, it's clear that there is a path forward for continued use of established litigation strategies à la milieu defenses, but there is also a bright future lying ahead with the adoption of due diligence legislation. So it's time for us all to think about how to use these new tools, and I leave you to discuss how this may be done. Thank you very much for having me today.